What we can say, we were just chilling in our offices and in other matters in court and other places, knowing that this matter comes up on first in the miscellaneous court, application in the court of in the lower court. But then the state, in its wisdom or lack of it, because I think it's lack of it, decided to bring today the OCS, Mr. Taalam, and the other persons to charge them for the offense of murder, knowing very well that these persons, being suspects at that particular stage, have lawyers. They did not inform the lawyers. They did not inform us at all. It is somebody who saw them putting the OCS into the car who informed us and told me, Mr. Ombeta, yes, are you aware that your client is going for plea? I called Mr. Omari. Mr. Omari also had just gotten information and he was in court. So we rushed here. So you can see, basically, when I was saying that they're legal bandits, I only meant that they are ambushing us. And when you're ambushing people, then that makes you what I said. It is not fair. Not only for the persons who we have come to represent, who we were very quick to react, but also for the ones who did not have their lawyers in court. Yet the state knows. They know the persons have their lawyers, and they know that these people need to be represented. And they know that in the High Court, nothing goes on if you do not have a lawyer. If they did not inform us, and this was intentional, then what did they intend to have as the last result? We know why they're in a hurry. We know why they are very happy, and Mr. Omari will address it. We know why they brought this matter to court today. And you know which date is coming up soon. So, must they joke with fundamental rights that belong to other people because they want to save their skin and play a public relations exercise? Is that what they want to do? Because they succeed in doing so. But then what about the rights of the accused persons and the persons who have been brought to court? Law must be seen. That sword must cut both ways. So today the OCS has been brought, but since two accused persons did not have representation, and the lawyers were not there present, the court cannot proceed. The hands are tied. So what the court has done is has given a date tomorrow. The state will come and we shall be able to proceed with the matter. But also remember that we had miscellaneous applications in the lower court, and we know that the procedure should be that the master, when you want to take somebody to charge them for the murder trial in the High Court, you come to the lower court and first of all close those cases and say, now the investigations are complete. We are now seeking to take these people to the High Court for trial, so that these other matters are closed and all that. But again, they usually put the cart before the horse, and I tend to think that this is not fair. So when I say and I call these names and I say who they are, at least let them believe me.
Well, it's very clear the defense never rests. Trial by ambush, don't tell the advocates, drag the people to court, they take plea, then detain them. Simply, it shows the incompetence of the state. Because the state, if they knew the law, they know that no plea will be taken for murder without an accused person having an advocate. They have come here and they have been chased. And the judge has said the two didn't have advocates, shall be given advocates. That's a big lesson. We know the reasons as to why a decision to charge was done today. Two things. There is a matter we filed before the Constitutional Court challenging the decision to investigate this matter without this matter going to an inquest. That matter is coming up before Justice Mugambi on the 30th of this month. This was a way to circumvent that hearing, so that on the 30th of this month, they'll be telling the High Court that already the people have been charged. That is the first reason. That cannot be in this country, a practice that is called sharp practice by the state. it is clear the person died in a police cell, and Article Section 385 will apply whether they take plea or they don't take plea. Number two, we know very well Gen Zs are going for demonstrations on the 25th of Wednesday. The hurry is to placate the Gen Z. But don't worry, we have already taken 6 people to court. We will defend these people not to be used for political reasons to stop the Gen Z demonstrations. We will defend the OCS. He was not present, but now he has been dragged here. We shall be filing shortly serious applications in this court to be heard tomorrow before the plea is taken. One of them, my brother Cliff, has said, no plea can be taken so long as there is a miscellaneous matter before a court of law. The case of Asha Nyakundi is very clear. He was taken by miscellaneous at Kibera, at Kiamburu Magistrates Court, then he was dragged to take a plea for murder. 5 judges found out that you cannot run concurrently. The miscellaneous must be filed, and it cannot be filed, it cannot be closed without the attendance of the respondents and the lawyers to be present. 2, we shall be asking this court to understand that there is a matter before the High Court coming up on 30th. And we shall be working very hard to ensure that justice is done. As we have said, the state should operate within the law. Anything else, the defense will never rest. We shall always be available to defend our client and the OCS. As I said, this is a witch hunt. This is a political witch hunt. The OCS has nothing to do with this matter, unless there's any questions.